Well, I wish I had something original to say about this. Almost all the adjectives have been used. I mean, obviously we have to caveat it. We haven't seen it. We don't know exactly what's there. But judging from the news reports, it's the archetypal abuse of the prosecutorial function to engage in a political hit job, and it's a disgrace if it turns out to be what we think it is. Politically, it's going to be damaging, I think, to the Republican Party, simply because I think it's a no-lose situation for the Democrats. I think the impetus is really to help Trump get the nomination, focus the attention on him for 2 years, have this thing swirling around plus whatever else comes, which I think will be damaging to whoever gets the nomination. And legally, I think it's from what I understand, it's a pathetically weak case. Taking the federal issue first, which is the way he appears to defeat the statute of limitations on a misdemeanor and juices up a technical misdemeanor into a felony. As you say, the federal government, the Southern District of New York, did not charge this as a campaign violation. And I saw some editorialist said something like, well, that's because Bill Barr was there. Actually, the Southern District could have done whatever they wanted. Well, I mean, they would have eventually.
I always heard that about them.
Well, but I want to point out that the administration ended 2 years ago, so Bill Barr wasn't there 2 years ago. And if the statute of limitations had not run federally, they could have done whatever they wanted to do after I left. So no one's done anything.
Right.
And so for the state DA to try to use this as a way of bootstrapping himself into a felony is sort of outrageous. But as the other thing is, the statute itself isn't as technical as it sounds. That is, it's not just falsification of a record, but the statute says with the intent to defraud. So the falsification of the record has to have the intent to defraud. It's not enough to say, well, the falsification is the fraud. There still has to be some victim of fraud, someone who is, some value is somehow taken away from and benefited, the perpetrator. And I don't see an explanation for that anywhere. So I think it's a very weak case just on the misdemeanor. And on the federal issue, they've gotten the statute completely wrong in my mind. And I don't think the department would support this interpretation of the statute that they're taking, which is that paying, well, I'll call it hush money, I don't like that term, but paying hush money is a campaign contribution. I don't think the department would take that position now. I think the statute covers two different kinds of payments. Something that's a campaign contribution because it augments the campaign resources available to spend on a campaign. That's not what this is. Or the payment of a personal expense that otherwise wouldn't be paid but for the election. The only reason you pay the personal expense is because the pendency of the election. And this was, even as alleged, this was a payment of a personal expense. And I don't think they can show it's not the kind of payment that would have been made in any case. Even it wasn't done because of the election. It was done to protect Trump's reputation. And an eponymous private company certainly has an interest in protecting the brand Trump. And it's the kind of thing that probably would have been paid but for the election. So I think the whole thing is a very weak case. But it's going to hurt our politics, obviously, for the next 2 or 3 years.
Apply the law equally across the board to everyone.
Right.
And we're dealing with a progressive prosecutor